Good afternoon. For those of you that don't know me, my name is Anna Galindo Marone. I'm the chief of the Hatch Act unit. And with me today is Erica Hamrick, who's the deputy chief of the unit. And as some of you may have read from the program, initially I was going to be the one doing the presentation. But given the new format, where we're doing this as a live streaming event, we thought it'd be best for the audience to have someone else that I could converse with and maybe work to anticipate the types of questions that normally we would have during a live audience. And we just thought this format would be more engaging for the audience to have the two of us sort of talking back and forth about some of these issues. I want to begin by saying that certainly we're not going to have the opportunity to hear from you all live and get questions, but at the end of the presentation, there will be a slide with contact information on how to contact Erica or me or the rest of the Hatch Act unit. And we want to make sure everyone feels supported this election season in being able to get timely advice from our office. So several things to that end that I was hoping to roll out to the group. Our office has been working on training videos to roll out during the election season. We're currently working on our first video that will just deal with political activity on duty. And in fact, Erica is the one that served as the guinea pig here. And she and Eric Johnson, who's another attorney in the unit, will be the first to have a discussion on one of the topics which we chose to be political activity on duty. These are going to be about 10-minute videos, right?
Yep, about that.
And so hopefully in the next couple of weeks, we'll have a rollout of the first video. And I also, speaking about videos, I want to give a shout out to Stuart Bender at USDA. Probably many of you know this, but for those of you that don't, he's really taken the lead with putting out some great Hatch Act training materials, in particular a video that's available on the USDA, I think, YouTube channel. And we think the video is terrific in terms of serving as an initial introduction and reminder for federal employees, especially for the less restricted employees. So I just wanted to say thank you, Stuart, for taking the lead on that, and it's inspired us to do our own videos as well. The other thing that I wanted to share with the group is that we have had, since the last election, we certainly have had, we never really got off the election cycle, and we've had more and more cases coming into the office and more requests for advisory opinions. In fact, right now, we're tracking a 33% increase over last year in terms of the number of Hatch Act complaints that we're receiving. And we expect it's only going to go up, so it's possible by the end of the season we'll see a 50% increase over last year. To that end, we are getting resources and staff support to help man the hotlines and be able to respond to complaints in a timely fashion. So we have 5 permanent attorneys, but we've also had 2 attorneys detailed to us in the last couple of weeks. One just started with us today, and she's actually here in the studio with us. So hopefully you'll be getting to meet these folks as you talk to us and call our office and engage with our office on Hatch Act matters. The last thing is I wanted to share with the group before starting the presentation is sort of the trends that we're seeing this year. And it's no surprise, I think I already mentioned, there's a significant increase in the number of cases and requests for advisory opinions. And we're seeing the trends around, in terms of the complaints, around political activity on duty. So Erica and I will hopefully be covering many of the issues that we are seeing or that we are likely to see, especially as we get closer to the election. We're also seeing more issues surrounding solicitation, and especially with so many employees now having social media accounts and being so fluent with these accounts, we are seeing a number of violations involving social media. So we will be addressing that. And unfortunately, we're also seeing an increase in the number of Hatch Act violations of what we consider a very serious nature, meaning that they involve the use of official authority or influence to affect the outcome of an election, cases involving supervisors and subordinates, cases involving individuals using their official position to advocate for candidates. So we will be getting also to cover those topics and give you examples of what we're seeing. The last thing that we're going to do is try to be mindful of the types of questions that we're getting in the office via the hotline, the Hatch Act inbox, or even at outreach, and hopefully share those questions with you in case these are some of the questions you would have had for us during the presentation. So I think we are going to start. And again, I'm mindful that normally this session has a mixed audience. You've got some practitioners in the ethics community that have been advising on the Hatch Act for many years, and then you also have some new people. So some of this will be basic, but then we're also going to include some of the more complex issues that we always bring to this conference. But the first point of discussion is to mention or identify who's covered by the Hatch Act. And it's every employee in the executive branch is covered by the Hatch Act, with the exception of the president and the vice president. Legislative branch members aren't covered, and neither are judicial branch employees. We still get complaints about the judicial and legislative, but clearly they're not covered by the Hatch Act. With respect to the executive branch, there are two categories of employees. You have your further restricted employees and your less restricted employees. The majority of the federal workforce is found under the less restricted category, which means that for most of the federal workforce, they're permitted to engage actively in political management and political campaigning, provided they observe the 5 prohibitions that we're going to be discussing. If you're further restricted, you may not actively participate in political management and political campaigning, in addition to the 5 prohibitions we're going to be discussing. And we'll give examples of what that exactly means in a short period of time. First, to identify who's further restricted, the slide that's up shows the agencies or units or components of agencies where all the employees are further restricted. The only exception with the further restricted agencies or components is the presidential appointees with Senate confirmation. They are still considered less restricted, even if they are employed in a further restricted agency. The next group of further restricted positions or employees are individuals that are holding the following positions regardless of their employing agency. So career SES, administrative law judges, contracts appeals board members, and administrative appeals judges, regardless of where they're employed, they're further restricted. And when we're talking about further and less restricted, we often get questions, especially from the intelligence community. There seems to be a lot of details that occur at these agencies. And so the rules in terms of detailees is that if you're going from what governs is the temporary assignment. So if you are currently, let's say, working at the FBI and you're further restricted, and now you are detailed to a non-further restricted agency, let's say the EPA, you would not be further restricted for the term of your assignment at the EPA. The only exception here has to do with individuals that are detailed from an executive branch position to the legislative branch. If that occurs, you're still subject to the rules of your executive branch position. And then with military folks that are detailed into civilian positions and civilian agencies, there's an additional consideration there in terms of their political activity, which is the DOD directive that they're covered under. So there would also have to be discussions with the Department of Defense to determine exactly what the political activity restrictions are that apply. The last issue that I want to mention in terms of coverage is that you're covered by the Hatch Act whether you work full-time or part-time. There's no difference. And also, if you're on paid leave, unpaid leave, or paid leave, you're still subject to the Hatch Act, as well as during the periods of time that we've been furloughed. So just be aware when I'm talking about the 24/7 prohibitions that these are considerations that employees need to have even when they're not at work and they're not on duty. Anything you'd like to add here, Erica?
No, I think you covered it.
Okay, so a lot of time is spent talking about what is prohibited. So recently, Erica and I, during the presentations, have been focusing initially on covering permitted activities to ensure that everyone understands what's permissible, because often the questions that we get on the hotline or in the Hatch Act inbox concern these permitted activities that hopefully everybody understands are not prohibited by the Hatch Act. And what you see now on your screen is a list of permitted activities that all employees, regardless of your status, whether you're further or less restricted, that you're permitted to engage in. And certainly registering and voting as you choose is permissible. Displaying campaign signs at home is permissible, and that's even if you're teleworking. And throughout the presentation, given the developing situation with the coronavirus, we will be discussing more of the telework issues that may touch upon Hatch Act issues as well. But often we're asked in terms of campaign signs, whether federal employees, when they're working at home, whether they have to cover their campaign signs, and they do not. Displaying political bumper stickers on your personal vehicle is permitted. Being members of political clubs or parties, being candidates for public office in nonpartisan elections, and campaigning for or against referendum questions, municipal ordinances, constitutional amendments, basically issue advocacy, if it's not specifically tied to a candidate or a political party, is permissible. And by the way, these are all activities that even at work would be permissible. Certainly not the campaign sign, but even when we're discussing issue advocacy, and we will get into a more detailed discussion of that, but these are activities that are considered nonpartisan and therefore permissible even when you're on the clock in terms of the Hatch Act. The next slide is a list of permitted activities that are qualified by your on-duty or off-duty status and whether you're at work. So all of these are permissible if you're off-duty and away from work, including contributing money to political parties, campaigns, or partisan groups, attending political rallies, meetings, or fundraisers, political fundraisers, signing nominating petitions, and following, liking, or commenting on the social media pages of a candidate for partisan office, a political party, or partisan group. Two other items to add here that we often get questions is wearing campaign buttons. These are not exhaustive lists, so often people will come up to me after a presentation and say, I didn't see under permissible activity wearing a campaign button after hours and, at home. Certainly, if you're not at work, you're not on duty, you can wear a campaign button. And the other question that we also receive here, especially getting closer now to the primaries and the elections, has to do with serving as an election judge. All federal employees are permitted to serve as an election judge as long as the work is being provided to the locality that's running the election. Especially because this is a slide that pertains to all employees. So if the activity was being done on behalf of a party, then the further restricted employees would not be permitted to serve as election judges. But if your service as an election judge is for a county, a city, or some other jurisdiction, then that would be permissible for all employees. The next list of permitted activities only applies to less restricted employees and is also qualified by the fact the employee has to be off duty and away from work. Circulating, nominating petitions, working as a campaign volunteer, distributing campaign literature, organizing campaign events, speaking on behalf of a candidate, holding party office, serving as a delegate to a party convention, organizing party events, serving on a party committee. These are all things that less restricted employees may do, and these are also examples of active participation in political management and political campaigning. That's why there's a difference here, and less restricted employees can do this, and further restricted employees may not. Other examples of questions that we are getting either at trainings or on our hotline, questions about serving as a poll watcher, a recorder, or a challenger. Again, these are all activities that less restricted employees may engage in. These are usually activities that are being performed on behalf of a campaign or a political party. And if you're less restricted, you're permitted to do these. Also, many lawyers ask as it gets closer to the election about serving on voter fraud teams or voter protection teams. And again, if you're less restricted, these are activities that you can engage in on your own time. Housing campaign workers, that has now come up as a question. And again, if you're less restricted, you're permitted to house campaign workers. If you're further restricted, you may not. Driving voters to the polls, again, that's usually a volunteer service that's provided to a campaign. That is something that a less restricted employee would be permitted to do. The last point here that I want to make is that we've been getting some questions about federal employees serving as electors to the Electoral College. And under the Hatch Act, that's permissible, but it is still prohibited activity for federal employees under the Constitution. For anybody that's interested in knowing the precise legal citation, or if you get a question from a federal employee, that would be found under Article 2, Section 1. But we are starting to see questions about participation in the Electoral College. Again, not a Hatch Act issue, but it is a constitutional question. Okay, so as we move in to discuss the prohibitions, we want to cover some of the basics. And for some of you all that are not new to this, you probably have heard us and you probably have read the definition of political activity a number of times, but it's worth repeating that in order for something to be subject to the Hatch Act, it really must fall within the four corners of this definition. And that is that political activity under the Hatch Act has been defined as an activity directed at the success or failure of a candidate for partisan office, a political party, or partisan political group. So there's a lot of activity that we receive complaints about that do not like the activity does not fall within the four corners. And in the next slide, you will see examples of that. But one of the things worth mentioning here that's coming up more frequently for us is what is a partisan political group. And certainly PACs, political action committees, are partisan political groups. The harder question that we're seeing concerns issue advocacy groups, social welfare groups. Many of these are organized as 501c4s. And in the past, there's been a presumption that because the stated purpose of the group is issue advocacy, that it would not be viewed as a partisan political group. But we recently, in the last, I would say, 18 months to 2 years,
I think that's fair.
We've had questions come up about groups, and the first thing that we always do when we get these issues is, if we've not done research on a group, is we go to the group's website and start doing some research. And so we have come across 3 groups that we have concluded, although they have a 501c4 status, given what appears to be the real purpose of the groups and their mission statements on their own websites, we've advised agencies that although 501c4s, They are partisan political groups for purposes of the Hatch Act. And to give you an idea, Indivisible is one of the groups, Republican Main Street Partnership, and Democratic Socialist of America. So those are three groups where we've concluded that these are partisan political groups. I suspect there may be more, but this is really an analysis that occurs on a case-by-case basis. And so stay tuned, because there may be an opportunity for us to engage with your office if you have an employee that's asking about one of these groups. So in terms of trying to further refine what is political activity or what is not, so certainly discussing legislation, ballot initiatives, nonpartisan elections, discussing those things, advocating for or against such things is not political activity for purposes of the Hatch Act, or discussing issues. The key here is that the employee, in their advocacy, in showing their support or their opposition, that they are not actually showing support or opposition for a candidate or a political party. So I'll give you some examples. Some of these are old examples. Some of these are very current. Obamacare. Now it's Medicare for all. These are politically charged issues concerning, health care in America, and whatever your view, whether you support reform, whether you do not, if all you're doing is discussing the issue and showing your support or opposition without also including a discussion of, therefore, someone, people need to vote a certain way, whether it's supporting a political party or opposing a candidate. If the conversation remains just about the issue for purposes of the Hatch Act, that's not considered political activity. We have this also unfolding with gun control issues, whether it's Second Amendment, whether it's gun control measures, the executive orders. There's been a lot of talk about executive orders with this administration, some of them affecting the unions. Erica's going to be discussing a case recently that we had with the executive orders. If all the individual is doing is discussing these issues and not tying it to a candidate, it's not political activity. Same thing with abortion, right to life, pro-choice. We saw a lot. Immigration is another hot button issue. The Kavanaugh confirmation is another one from recent history, where again we were receiving a lot of questions, a lot of complaints about people being upset that these things were being discussed at work. Again, if not tied to a political party or a candidate, then probably not political activity. Lastly, a lot of questions about issue marches and rallies. Last night I had to respond to someone in the Hatch Act inbox that was asking about participating in an upcoming gun rally. We've had March for Life, Women's March, March for Science. These things on their own, attending one of these, participating in one of these rallies is not considered political activity per se.
Yep. So let me talk about the case that we had where an employee took the issue advocacy a little bit too far in violation of the Hatch Act. And this was a federal employee who had brought to the workplace copies, printouts of a news article that discussed the executive orders that impacted unions. And if the only thing he had done was distribute those articles at work, it would have been fine. It would not have been a Hatch Act violation. What the employee did, though, was he hand wrote at the top of the article before photocopying it, "If you like your good-paying union job, this is why you do not vote Republican." So he was tying that issue advocacy with the failure of a political party. Now his distribution of that article constituted political activity, and he violated the Hatch Act.
And in fact, as Erica was speaking, I just looked down at my notes. We just had an issue come up about the coronavirus.
Yes.
So why don't you took the
Right.
issue?
So, right, there's probably going to be a lot of discussion in the workplace about the coronavirus, and maybe even discussion about whether the administration is, succeeding or failing in its response to the coronavirus. And again, those kind of discussions are not going to rise to the level of political activity. However, the question I just received yesterday is somebody wanted to post a sign, I have it here, that says, "Wash your hands like you just shook hands with the president." And so the idea being that washing your hands to get rid of something bad, such as, the president, we've concluded that it would be political activity to display that in the workplace.
And then I think you also had, we had the whole case. You want to talk about the box case?
Oh, yeah. So we had another case. Well, it actually didn't end up being a case. The person called for some advice, and we gave them the advice over the phone. But the person was calling because they were disturbed by actions of another employee in the workplace who was actually building a physical wall made out of boxes in the workplace. And so the employee called because they were concerned that this employee was making some kind of political statement about immigration. However, in the end, the only thing the employee was doing was building a wall of boxes. And so it wasn't tied to any candidate or political party. So it was difficult for us to conclude that merely building that wall constituted political activity. And so we advised the person accordingly.
And, one of the things that when we have a live audience, that sometimes, someone will raise their hands and ask, well, but clearly some of these issues are associated more so with one political party or a candidate. And we recognize that many of these issues that we've brought up here are politically charged, but that doesn't necessarily mean that that is reflecting how someone is going to vote or the political party they belong. With a lot of these issues, one of the issues that comes to mind is support for the NRA. There are plenty of individuals from both political parties that support or are members of the NRA, so we can't assign political party political party support because someone feels very strongly about certain issues. They may feel strongly about an issue, but maybe vote a different way at the end of the day when they get to the ballot box. So that's the response that we usually give individuals when we're asked about these politically charged issues and why we've concluded it's not political activity. So the first prohibition that we're going to be discussing is the prohibition that I always describe as a time, place, manner restriction. All federal employees, with one exception that we'll cover in a minute, but pretty much all federal employees are prohibited from engaging in political activity on duty in the federal workplace, while wearing official insignia or uniform or using a government vehicle. And I want to discuss these each in turn. The majority of the violations here occur either in the on-duty or in the room or building category. On-duty basically is defined by the regs, and you're either in a pay status other than, for example, paid leave, your sick leave or annual leave, or you're engaged in the official discharge of duties. And this includes teleworking and even official union time for those employees that a percentage of their time is considered official union time. When they're performing those official union duties, you're considered on duty for purposes of the Hatch Act. Going back to teleworking, one of the things as we were thinking about this presentation is that we're seeing notices being put out by our agencies, by OPM, the possibility that some or many of us may be teleworking for a period of time, an extended period of time. And one of the things that we were talking about as we were coming over here is that sometimes when we're teleworking, we might become a little bit more casual. We're not at work. So we might be more mindful and thinking about the Hatch Act while we're at work. But if we're home, you're at home, even though you're working, it's a much more casual environment. So it might be worth, if our agencies move into a telework situation because of the developing health concerns, that we remind everyone about the Hatch Act. And that they're still subject to it while they are performing their job at home. So that is one thing that I think is sort of, we normally don't emphasize so much teleworking, but I am concerned about this new framework that we might all be working under. The agency, in terms of what's a federal room or building, for agencies that wholly own or lease a building, the entire space is subject to the Hatch Act rules. And this includes the public spaces, the break rooms, the conference rooms, gyms, people that want to wear campaign T-shirts off duty to the gym. If the gym is in a federal facility, can't do that. The cafeterias, some agencies have cafeterias. Even if you're off the clock because you're at lunch, and you're even using your personal device, if you're in the agency cafeteria, you're still subject to this on-duty or in the workplace prohibition. The union office, if it's part of the federal facility, inside the facility, is also subject to this rule. So you need to be aware that even though you may be off the clock in what you consider a public space in a federal facility, that you're still subject to this restriction. One of the things that we're seeing in particular with public spaces, and we're seeing this, we've seen this for many years, but we're seeing this more than ever. I think we get at least 1 or 2 questions a week about this, is the TVs. Agencies that have TVs tuned to a news station in public spaces, whether it's CNN, whether it's Fox, MSNBC, or any other news station, just merely having a TV station, a television tuned on to a news station in a public space is not a Hatch Act violation, okay? We understand that some of these stations have political content or are reporting on even the campaigns. Any station now, you turn on a news station, they're reporting about the campaigns. Again, we want to reiterate, it is not a Hatch Act violation for agencies to have their television sets turned on to one of these. Do you have anything else to add?
No, I think you covered it.
Okay, just want to reinforce that. Okay, so still in this area, use of government vehicle. Clearly, if you have a government vehicle that you use for official purposes, should not be used to engage in political activity. And if you are wearing an official uniform or official insignia, you should not be engaging in political activity. The only exception that I can think of here that comes up during the election season is people that wear uniforms for work and have asked if they have to go home and change before going to vote. And we've advised that you do not have to go home or change before going to the polls to vote on election day, okay? Do you have anything to add about uniforms? Oh, here's another a question that we get. People, especially less restricted employees that are going to volunteer to work for a campaign, be careful not to wear, if you have an agency hat or a T-shirt that has your official agency logo. If you're going to be engaged in political activity on the weekends or off the clock, make sure that you're not wearing anything with an agency logo.
Even your ID, like your government.
That's right. We've had cases
ID.
with the government ID, people wearing their government ID. I think am I ready to turn it over to you?
Are.
Yes.
Oh, to me?
No.
You are, absolutely.
Wait, are we doing the examples?
Do you want me
Wait
to
a
start
minute. Let me see where we are. Sorry.
Exception.
I'm sorry. Oh, the exception. Do you want to do the exception? You want me to do?
I do.
Okay, I'm doing the exception. Okay. So, let me I think my notes are out of order. Okay. Sorry, folks. Okay. So, the exception for this prohibition concerns presidential appointees with Senate confirmation and some individuals that are employed basically at the White House. There are what we call EOP employees. They're paid with an appropriation from the Executive Office of the President. But we are talking here not about all EOP employees. We're talking about the most senior advisors at the White House, the commissioned officers. So that's your universe, your PAS, and these very senior officers at the White House. These individuals may engage in permissible political activity while on duty in a government room or building. And the qualifier here is that the costs associated with the political activity may not be borne by U.S. Treasury funds. So let me give you an example. You have an agency principal that maybe has agreed to go and support the president and will be going out on the campaign trail and speaking at a campaign event. And in order to coordinate with the campaign, the agency principal needs to have what would typically, be a clear political, call with the campaign to strategize on the talking points, let's say, that the agency principal is going to be delivering. If you don't follow, all federal employees, with the exception of the PAS and the White House officials, would not be permitted to have such a conversation with a campaign or a political party. But the exception would allow the agency principal to have that political conversation with the campaign to strategize on what the talking points for the political speech are going to be. Another example would be the agency principal may be hosting a political meeting in his or her office. The costs associated with that meeting, for example, if they were going to serve refreshments or sandwiches during the meeting, would not be expenses that the federal government would be paying for. This is something that the campaign would have to pay for, the political party, or the agency principal would personally have to pay for that cost. The other thing to bear in mind here is that this exception, going back to the meeting in the agency principal's office, this meeting and this exception only applies to the PAS. So the support staff cannot be brought in to perform political chores to support that meeting or to perform any other political chores for the PAS, because again, the exception only applies to the PAS. The other thing that I want to emphasize here is that this exception, when you read the legislative history, was really carved into the statute with the concern that these individuals that we're talking about, whether it's the White House commissioned officers or the agency principals, the PAS, they are considered on duty 24/7. And so the concern here was that arguably then the statute would prohibit these individuals from engaging in political activity at any time because they're 24/7 employees. So that was the purpose of creating this exception. But it's even clear from the legislative history that the idea would be that the political activity that these individuals would be engaging in, if on duty, would be incidental to their official duties, basically de minimis activity, and that the majority of the political activity would occur outside of what's normally considered the official core hours. So that's the purpose, and that's why I just want to emphasize that it's permissible political activity and it should be incidental. The other point that comes up here under this exception is the mixed travel that many of the agency principals, the PAS, engage in. And for those of you that are advising the agency principals, I suspect most of you are very familiar with the Hatch Act regulations that discuss mixed travel and the proper allocation of the trip, determining what part of the trip is official, what part of the trip is political, and then applying the hard time formula that's found in the Hatch Act regs. And sometimes these can be complicated issues, so please feel free to call Erica or me at any time. We often talk to many of you and walk you through how to figure out what's official and political and apply the formula. The last point that I want to raise here has to do with, we've been getting questions about who's traveling, especially with it's clear that with mixed travel, The agency principals typically will have, for example, if they have a Secret Service detailed to them, they're going to have Secret Service traveling with them. And often we also know that like an executive assistant travels with the agency principal. And that is certainly fine when you have mixed travel. The more difficult question that we're seeing has to do with when the travel is wholly political. And I want to be clear that the advice that our office is giving is that the assessment the agency needs to make, and our starting point is that certainly the regulations make clear that only those individuals that are required to travel with the agency principal in order to perform their duties should be traveling with the agency principal. And from our perspective, there aren't three categories of travel. It's not like there's official travel, personal travel, and political travel. It's either official travel or it's non-official travel, right? It's personal travel. And if it falls into the non-official travel, then there needs to be, a serious consideration of who is truly required to travel with the agency principal, and who typically travels with the agency principal if the question is that it's non-official. So if you have any questions about this, please feel free to call our office. We've been talking to many of you already about these issues. Is there anything you want to add here? No?
Do you want me to go?
Yes.
Okay. So for those of us who are subject to the on-duty in the workplace prohibition, really this prohibition is getting at any show of support or opposition to a candidate, a political party, or a partisan group. So that's going to be whether that is in a button, a t-shirt, a hat, or something you have displayed in the workplace, whether it's a sign, a bumper sticker, even a screensaver on your computer. All of that is going to be prohibited in the workplace. I want to give you a couple examples of cases that we've seen of what employees are actually doing in the workplace these days. So we've had one case that we investigated and actually are working on a recommendation for some disciplinary action. It was an SSA employee who, as part of his job, he dealt with members of the public, face-to-face interaction, providing customer service at like a customer service window. And what this employee decided to do one day to work, after the day before posting on Facebook a picture of his Make America Great Again hat and how he was going to wear it to work the next day and tick everybody off, he did just that. He wore his Make America Great Again hat to work while he was interacting with members of the public. And he actually provided services to at least 3 customers, 3 members of the public, before his supervisor realized what was going on and pulled him from the service window. Make America Great Again, it's a campaign slogan of the president who's running for re-election. Obviously, wearing that hat, displaying that hat in the workplace is going to be a Hatch Act violation, as this employee did. And this is an issue that we're seeing in the workplace is federal employees not just engaging in political activity on duty, but while they're performing their official duties. And we've seen a rise in cases where they're performing their official duties while they're actually interacting with members of the public. And that's very troubling, given the purpose of the Hatch Act and the idea that the government is supposed to perform its job neutrally. We had another case with an employee who wasn't dealing with members of the public, but he was giving a PowerPoint presentation to some coworkers and also some contractors who were there at the agency. And what this employee did, he was a security specialist, and his PowerPoint presentation was on that subject matter, but he decided to include some graphics that said "Vote Republican" in his slides. And he did this even though the day before, when he showed one of his coworkers the presentation, his coworker gave him some feedback and said, I don't think it's a good idea for you to include "Vote Republican" in your slides, but the employee did so anyway. Again, on duty in the workplace and clearly advocating for a political party. That employee, that case has resolved. He actually served a 30-day suspension without pay for his activity. And then the last case here I want to talk about, again, another case of an employee interacting with a member of the public, another SSA employee who was manning a hotline. So he would take calls from members of the public and answer questions about their benefits and what have you. And on this particular call, the official business of the call was resolved in about 3 minutes, but the call went on for another 21 minutes. And during that 21 minutes, the employee discussed with the member of the public the Democratic primary election. He discussed, the conversation started with a discussion about Medicare for All. The employee gave his opinion about Medicare for All. He mentioned how he's not really supposed to talk about politics, but then proceeded to do so, talked about how Warren and Sanders might have a fighting chance against President Trump, but Biden basically did not. He was not the man for the job. Also at one point, this was going back early in the primaries when Kamala Harris was still a candidate, he basically called her a hypocrite during the call. Again, this went on for many, many minutes, and at the end of the call, the caller said that he appreciated the conversation, and it's given him more interest in then-candidate Warren. So a really serious violation of the Hatch Act, providing customer service, has a captive audience on this hotline, and is basically giving his opinion about all the Democratic primary candidates. That particular employee, we had investigated that case. We were planning on pursuing some disciplinary action. He ended up resigning from his job before we could do so. So just a couple of cases to give you an idea of what's going on in the workplace. Another issue that comes up a lot when we're advising on this particular prohibition is questions about photographs of candidates. And this comes up a lot, particularly in a presidential election year. And so the Hatch Act regulations say that you cannot display a partisan political picture in the workplace. So our starting point, our starting advice is that if the individual is currently a candidate for partisan political office, then you shouldn't have a picture of that individual in the workplace. However, we have two exceptions to that kind of general rule. One deals with pictures of the president. So even though, for example, right now the president is the president, he's also a candidate for re-election. And so what we've advised with respect to the president is that if it's the traditional, headshot portrait of the president that you see when you walk into any federal building, a federal employee could have that headshot displayed in his or her office, as long as it's displayed in a traditional size and in a traditional manner. For example, we had one employee who had the headshot picture framed, but then had an I voted sticker on it. And we told her that was a problem. The sticker needed to come down. It wasn't a traditional manner. The other exception, and this is going to apply to any candidate, not just the president, is what we call the personal photograph exception. And that is that the employee is in the photograph with the candidate, and the picture has some kind of personal significance to the employee. Maybe it was taken at a wedding. Maybe the individual was a member of the employee's wedding party. Now, many years later, that individual is running for office. The employee doesn't have to take down that personal photograph just because the person is now a candidate. So that's the personal photograph exception, and it would apply to the president and any other individuals running for office.
Erica?
Yes.
What about the vice president? Because someone asked us that
Oh,
question
that's a great
yesterday.
question. In terms of the vice president, the same advice would apply regarding the official portrait. The official portrait of the vice president could be displayed as well.
And did we recently receive, because I feel like someone called in and asked about the former vice president, Biden. They had a picture in their office when Biden was vice president and they were receiving some sort of award. What would we say there?
Right. So in terms of the personal photograph exception, we've said personal, the photograph was taken at a personal event or maybe even some kind of professional event. And so an example like that, where in the previous administration you had an opportunity to go to the White House, you met the vice president, maybe you were receiving an award, had a photograph taken with Vice President Biden, certainly that photograph would be okay in the workplace now. A couple other things. Well, actually, let's get to some examples,
and then
we can talk about emailing and texting and social media, which is really the big topic in this area. Okay, so Unfortunately, I don't have an audience to raise hands or give me
It's like-
thumbs up, but in terms of these these pictures here, so the Hillary Clinton, the former campaign logo, she is not, as of yet, a candidate for anything. So having that logo displayed in the workplace would be fine. Now, if she decides to jump in the race, either as a presidential or vice presidential candidate, at that point in time, you would need to take down the 2016 logo. Same thing with the picture of President Obama. Miss me yet, President Obama is not currently a candidate for any office, so displaying his picture in the workplace is not going to meet that definition of political activity. Now, the Trump 2016 campaign button, even though it's from the last election, President Trump is currently a candidate for re-election, and so past campaign items from his campaign are going to be prohibited in the workplace.
Oops. Oh, yeah.
Yeah. So, okay, so these 4 items here, these are actually all going to be fine in the workplace. The Hatch Act wouldn't prohibit them. In terms of conservative versus liberal, certainly, you may associate being conservative or liberal with, being a member of one political party or the other, but really these are political ideologies. They're not political parties, and the Hatch Act wouldn't prohibit an employee from displaying these signs in the workplace. The National Rifle Association, I think Anna mentioned earlier, it's an issue advocacy group. Having a mug with National Rifle Association would be fine in the workplace. And then the same thing with Moms Demand Action. Again, issue advocacy group, it's going to be okay in the workplace. So these items here, we'll take them in order. The hashtag MAGA, Make America Great Again. Again, campaign slogan for President Trump. That cannot be displayed in the workplace. Same thing with Trump with the line through it. Clearly an anti-Trump, message there. Never apologize for being right, except that the R is the GOP elephant. So that's showing support for the political party. That would be a problem in the workplace. If the mug had an actual R and not a GOP elephant, and it wasn't coming from a campaign or a party, then that message would be fine, because again, it's going to kind of that political ideology. But the GOP elephant tips it into the political activity category. And then the last one, the Trump chia head, it's not a traditional portrait of the president, and so we've advised that right now that needs to go into a drawer until after the 2020 election. Okay, so some of these items here, we are continually updating our presentation as the primary goes through, but we do have still some current candidates on this this slide. So feel the burn. Bernie Sanders is still a candidate. Same with former Vice President Biden. You can't display their campaign materials in the workplace. Mayor Buttigieg and Mayor Bloomberg, they are no longer candidates. So you actually, if you wanted to get your Buttigieg sweatshirt out and wear it in the workplace, or the I Like Mike hat, that would be okay at this point in time. And then again, going back to the Make America Great Again hat, Make America Great Again socks. We actually did have a case where a cabinet official wore those socks to work, and not only did he wear them to work, there was a photograph of him wearing them on his official social media account, which was a problem that we will talk about in a minute. But yes, those are clearly campaign items, and they can't be in the workplace. Okay, so these here, so I'm going to go to the end first. So this last T-shirt, the College for All, Medicare for All, Jobs for All, Justice for All, on the face of it, it seems like an issue-oriented or issue advocacy T-shirt. However, if you can see on the sleeve, it's actually a Bernie Sanders campaign T-shirt. So the Hatch Act is going to prohibit employees from wearing that in the workplace, even if, as someone has asked me, they roll the sleeve up so you can't see the Bernie Sanders. It's still a campaign shirt. It can't be in the workplace. This next T-shirt, Doors Not Walls, this is actually a campaign T-shirt as well, even though it may seem like the issue, advocating on the issue of immigration. This was a T-shirt from the Mike Bloomberg campaign. So when he was a candidate, employees would be prohibited from wearing that shirt in the workplace. Now that he's no longer a candidate, you could wear your Doors Not Walls shirt in the workplace. The Build the Wall and Crime Will Fall bumper sticker. So generally the issue of immigration, building the wall, I talked earlier about the box wall that someone was building in their workplace. Generally that's not going to be considered political activity. However, in this particular case, this bumper sticker, it comes from a campaign. It comes from the Trump campaign. So it is actually a campaign bumper sticker, and it's not going to be allowed in the workplace. And then any functioning adult 2020. This question came up during an outreach presentation about a year and a half ago. And at the time, I had an idea in my head about what the message was, and came back to the office to talk with the rest of the unit about it. We did a little research into the genesis behind it. And we've concluded it is political activity. And the reasoning behind it, and the reason that someone created the sticker in the first place, is the idea that any functioning adult 2020, the reference being that the current occupant of the White House is not a functioning adult. So it's an anti-Trump bumper sticker. We've advised against displaying it in the workplace. But speaking of bumper stickers, a question that comes up quite often are employees want to know if they have a partisan political bumper sticker on their personal vehicle, can they still park that vehicle in a government lot or garage? And the answer is they can. A bumper sticker, 2 bumper stickers, partisan political bumper stickers are going to be okay on the personal vehicle, even in a government lot or garage. What we advise employees not to do is basically make their vehicle a campaign mobile. And we've seen it. We've seen cases where employees have basically shrink wrapped their entire vehicle in a campaign sign, or have had a giant campaign sign in the flatbed of their truck. That kind of activity is going to be prohibited in the government lot or garage.
And Erica, is there some point, even with the person that has one bumper sticker, where they actually have to cover it?
Yes, that's a good point, Anna. So if an employee uses their personal vehicle for official business on a regular basis, so for example, a postal service employee who uses their vehicle to deliver mail, they would need to cover any kind of partisan political bumper sticker while they're engaged in that official business. Okay, lastly, so we include this slide just as a reminder that this prohibition, it's not just about candidates, it's about political parties as well. So all of these items, whether it's the conservative Republican button or the women work, women vote for Democrats bag, all of that is going to be prohibited in the workplace.
So, so still on duty workplace issues. The last thing I think to cover is sort of where we see the majority of these violations, right? And that is the use of emailing, social media, blogging, texting to show support or opposition for a political party or candidate for partisan office. And often, people will tell us that they were not the author of the email or the text, that they're just merely forwarding or sharing. But there's no requirement that you be the author of the material in order for it to be political activity. If you are further distributing content that is for or against a political party or candidate for partisan office, you're engaged in political activity. It also does not change the analysis if the audience that you circulated the material to are people that are like-minded. Often the people that we target, right, for reinforcement and encouraging them to go vote are the people that we know feel like we do. So the fact that you sent these messages or texts to someone that's like-minded does not remove it from being political activity. Also, using a personal device or personal email account does not also remove it from being political activity. If you're at work or you're on duty, you cannot use even personal accounts to engage in political activity. And one of the things that we've seen recently in terms of texting, and then I'm going to turn it over to Erica to discuss some of the cases, but last week I had someone who self-disclosed because it goes to show you this example, how casual some of this can be and how inadvertent this violation was. An individual was at work. It was a Monday. They had contributed to a campaign over the weekend. And while they were at work on Monday, they received a text from the campaign asking if the individual would be willing to contribute an additional amount of money. And the individual clicked and said yes and made another contribution. And as they clicked and agreed to the additional contribution, they realized that they had just violated the Hatch Act because they were at work. And so they self-disclosed, and certainly we recognize that things happen and it was inadvertent. The agency contacted us and we told the agency that we thought, given the fact the person self-disclosed and there was an assurance that this wouldn't happen again, that the matter was taken care of. But it goes to show you just how casual and how quickly someone can violate the Hatch Act, given all the technology and that we have at our disposal. And then I think Erica will talk about this, but we've had a couple of examples, like with Skype for Business at work.
Do you want to?
And Signature. Do you want me to? And then you'll.
Go ahead.
Okay. So two of the other things that we're seeing at work, one involving email, has to do with signature blocks. We've had folks include in their signature blocks, and this has happened in the past, campaign slogans. We recently had one where it was MAGA and DACA. Clearly political activity because they're using the campaign slogan. We also had another one recently where someone in their official email account, the signature block, they decided to have a picture of the president appear with each email that they send out. And we told the individual that even it was the official picture, which it was not, but even if it had been, that was not a traditional display of the picture of the incumbent president. And so the individual was told they were violating the Hatch Act, and they came into compliance and removed it from their email account.
So there are many, many examples that I could go into dealing with social media and electronic communications, but for the sake of time, because we need to keep an eye on it, I'm just going to talk about a few. One, just I want to point out that we have investigated and resolved several social media cases over the past few years since the 2016 election, and a lot of them have resulted in some pretty significant disciplinary action. And these cases involved employees who were, repeatedly engaging in political activity on social media while they should have been, performing work for the government. Sharing posts, making their own posts, both on Twitter and Facebook. We've settled cases, one case for a 50-day suspension. We had another case where an employee actually resigned and accepted a 5-year debarment for her violation. So we've seen it continuously since the 2016 election, and we have some current cases going as well. In fact, there's a case that we're investigating right now where the evidence is showing that this employee over a several-year period engaged in significant amounts of political activity on Facebook, a lot of sharing of memes, and we're seeing memes a lot more in cases, and these are, little pictures with words that I guess people get from the internet and then decide to share them on their Facebook page, but some of these have a very strong pro or anti-Trump or other candidate message, and in this particular case, this employee was engaging in an extensive amount of this activity, again, over several years, and so it's a case that is very serious and likely is going to be going the route of some discipline. We're also investigating a case where the employee was doing all kinds of things at work and basically running the local Republican Party out of his work site. We have evidence that he was, composing emails and letters, posting things to Facebook, posting things to the political party's website. There was even some fundraising. I mean, the amount of evidence of the time that he was spending at work engaging in political activity in support of the Republican Party, again, very extensive. So it's something that we're just continuing to see over and over again in the cases that are getting filed with our office, where employees are just using their government time to engage in political activity instead of do their jobs.
Two quick things
yes,
before
absolutely.
we move on. One, you might want to mention profile pics.
Oh,
because
right.
that is bound
So
to.
we do get questions a lot from people about their Facebook profile pictures and whether they can make their Facebook profile picture something that's campaign related. So maybe a campaign logo, maybe a picture of a candidate, or maybe some kind of campaign slogan or something like that. And that's going to be fine from a Hatch Act perspective. However, you're not going to be able to post anything on Facebook while you're on duty or in the workplace. And the reasoning is because that Facebook profile picture follows you around Facebook. So whether you're posting a message or sharing somebody else's message, that Facebook profile picture gets posted along with it. So if you make that picture something that's campaign related, then you're basically posting that campaign picture every time you post or share something on Facebook. And if you're doing that while you're on duty or in the workplace, it's going to be a Hatch Act problem.
And then the last point is the news clips that you just recently circulated.
I did.
Sorry.
Right. So we every election cycle, we get some complaints or some questions from employees about news clips that agencies circulate to all employees. And a lot of times when we've investigated, we have found some common practices that have been problematic. And so we recently issued some guidance to try to, and actually in response to people asking us to do so, and to try to kind of tackle some of those common issues. Because the thing that we don't want to happen is we don't want agencies to be sending basically political op-eds about candidates to their employees. And so
And we've seen that.
We have, absolutely. I mean, we've seen cases where, maybe an agency has a contractor who's running search terms to pull articles that are related to the agency, but within those search terms, a political op-ed gets pulled, nobody's reviewing it, and it ends up getting sent out to all employees, and then we end up getting a complaint about it. We've also had agencies where they're basically just pulling from all the major news networks, like the headline news of the day. And during an election cycle, the headline news of the day is going to be about the candidates and about the elections, and so we've received complaints about that. So the guidance that we issued, it warns agencies against, including political op-eds in the news clips. It suggests that employees should have practices in place so that somebody is actually reviewing the articles before they get distributed to employees to make sure that there isn't some kind of article that's inadvertently put in there. And then importantly, any article that maybe mentions the agency head or agency principal, but that agency head or principal is engaging in political activity. So maybe an article where the agency head has endorsed a candidate, or maybe an article about an agency head, appearing at a political fundraiser the night before. Those types of articles should never appear in news clips that are distributed to all employees.
Okay, great. So I think we're moving on to the next prohibition.
Let's see the time.
Yeah, because 3:15, right?
Yeah, we have.
Sorry. Okay. So the next prohibition, which many of you are probably familiar with, is that all federal employees may not solicit, accept, or receive political contributions. And I think it's important here to emphasize that this is a 24/7 prohibition, and it's solicitation by any means at any time. Sorry. And so we often get questions here concerning, for example, hosting a fundraiser. And certainly hosting a fundraiser is prohibited. Inviting someone to a fundraiser is also prohibited. Sharing or liking, and this brings in the social media aspect, but sharing or liking posts on social media that include a donation request is also prohibited. Any way that someone can further distribute a donation request would be prohibited. Recently, someone at a presentation asked about circulating campaign literature. They're less restricted. They're going to be canvassing the neighborhood with campaign material, and they wanted to know what they should do if what the campaign is asking them to circulate includes a solicitation. I advised them that they would not then be permitted to be handing out that campaign piece. Same thing with phone banks. If individuals that are less restricted are being asked to work phone banks for a campaign, they need to ensure that the script that they're going to be reading is not one that requires them to solicit for political contributions. Let me just I know that we're running short on time, so I just want to make sure we cover some of the key points. in a presentation last week, someone pointed out, and this is something that we haven't talked about in the past, when it comes to social media, we've always said that you can't share or like what's being posted to your page. But if someone else is posting to your page a donation request, you're not responsible for having to constantly be monitoring your Facebook page and deleting those, because it's not your solicitation. But recently I was informed that Facebook does have a feature that some people have on, which allows them to decide what content, what posts they're going to permit to appear on their timeline. And if the person you're advising is someone that has that feature on, then they will be viewed as soliciting if they permit the donation post to appear on their page, because now they've made a decision to allow that to appear, unlike the individual that does not have the feature on. So that's something new that just came up that we've not in the past been talking about. Is there any other main points here before I turn it over for cases? So then I'll let Erica cover some of the cases.
I'm going to just talk about two cases,
Yeah.
unless you want me to talk about more.
Okay.
They both deal with social media and two different kinds of social media. One case involved an employee who was serving as a party chair in his state, which was fine. He's a less restricted employee, and that was okay. But what this employee was doing was on his Facebook page, he was sharing fundraising invitations for local party fundraisers. So he was actually at the state level, and so each county within that state would have a party fundraiser, throughout the year, and he would share those invites on Facebook. And he also was engaging in some activity, not fundraising, but some other political activity in the workplace. So he had some on-duty violations in addition to the sharing of the fundraising posts, which was the solicitation violation. And that employee is currently serving a 90-day suspension without pay for his violations. And then the other case actually involved LinkedIn, which we do not get a lot of cases that involve employees engaging in political activity in LinkedIn, but we have started getting some more questions about them. And in this particular case, this employee had a LinkedIn profile and was using it for the reason people use LinkedIn. It's kind of a professional networking site. So in his Facebook or his LinkedIn headline, he had his title and his agency. And what he did was he had a friend who was running for office, and for partisan political office, he posted a message, encouraging people to support his friend and also encouraging them to donate money to the campaign. It was very explicit, please give my friend money. So we found that to be a solicitation violation. And in addition, because his LinkedIn profile had his title and his agency, it looked as if he was soliciting in his official capacity, because that headline kind of follows him around like the Facebook profile picture everywhere on LinkedIn. And so he solicited with the title and the agency there as well. And so we looked at it also as a potential, use of official authority violation. And we're currently trying to settle that case for some disciplinary action.
And the last thing that I want to add here is that it's something I didn't say in the opening statement, but it's a question that even came up yesterday when we were doing a presentation with agency counsel, is that these rules, all the restrictions that we're discussing, only apply to partisan elections. Doesn't matter whether it's at the federal level, state level, or local level. As long as the election is partisan, these rules apply. And so often I get questions about solicitation and acceptance of political contributions for federal employees that are running in nonpartisan office. And the Hatch Act rules, these restrictions would not apply if indeed the individual is running for nonpartisan office. I do always tell the individual that they should check with their agency ethics office to ensure that there aren't other considerations. And we actually do that often for many of these issues, even like issue advocacy. Just because it's not covered by the Hatch Act doesn't necessarily mean that we are encouraging people to engage in this conduct at work. So we always tell them that they should have a conversation with the agency ethics office before proceeding. But I wanted to emphasize that if it's a nonpartisan office a federal employee is running for, then this solicitation and acceptance prohibition does not apply. Oops. Keep going. Okay.
There you go.
Okay, there. So the last point with fundraising that I'll go over very quickly is that there is an exception that applies to members of union employees. If you're a union employee, you are permitted to solicit for political contributions. However, you may only solicit for the union's PAC. You may not solicit a subordinate, and the solicitation must occur off-duty and outside of the workplace. So it's a pretty narrow exception, and all of these things, all of these requirements have to be met in order to fall under the exception. The next prohibition, which is where we see often many of our most serious cases, concerns one's use of one's official authority. That is that all employees, there's no exception here, may not use their official authority or influence to affect the outcome of an election. And here, I think many of you know that clearly this prohibition affects and governs the relationship between supervisors and subordinates under the case law, which many of you are familiar with. The case law finds that the relationship between a supervisor and a subordinate is inherently coercive, so no magic words are necessary when advising, suggesting, directing an employee to engage in political activity. And we've got some new examples. I think Erica's going to be covering those. Do you want to cover those and then I do the next point, or do I cover all the points first and then?
Go ahead.
Go ahead.
Well,
Okay.
yeah.
So the next point that this prohibition covers has to do with the use of one's official title or position. So the example that Erica gave earlier, where you had the gentleman wearing the MAGA hat while working with taxpayers, or the other individual that had this very lengthy conversation with a taxpayer who was seeking advice from the agency, and he was assessing the Democratic field and who people should be considering. Those not only were political activity on duty violations, but they were also a violation of this prohibition. That's someone in their official capacity who is interfering with the results of an election by advising or suggesting to individuals how they should be voting. The other area that we see here has to do with especially agency principles, but it doesn't have to be an agency principle. We've had several cases this past year in 2019, involving individuals that go out and speak to the public, and during their presentations, whether again it's the agency principal talking to the media or a career employee talking to an audience, they have, in both instances, individuals are maybe likely to get questions from about the election, right? And during the discussion of the election, they'll be asked to weigh in on the election or a candidate. And what we are consistently telling everyone that is out speaking in these public speaking engagements or talking to the media is that they cannot weigh in on the election or the candidates. If they're being asked about the election, the impact of the election, they need to pivot. They need to pivot away from discussing candidates or elections. Of course, that does not mean that administration officials can't talk about the successes of the administration. Of course they can. They can talk about the administration's successes, what the administration is doing. Every incumbent president that runs for re-election, the administration is out there doing its job, and of course they're permitted to discuss what they're doing and their successes. What we're advising cannot happen is what we've seen in the past, where you have an administration official who now starts to discuss the candidate field. That would be a violation of the Hatch Act. The last point here has to do with the use of agency resources, whether it's official social media accounts or agency website. We need to ensure that these accounts remain neutral and do not contain partisan content. For example, links to political parties, links to campaign websites. And I'll turn it over to Erica.
Okay. So a few cases to talk about within this prohibition. One case is one that we actually took to the MSPB and have an ALJ decision on. And this case is a serious one and one that we took very seriously, obviously. It involved an immigration judge back in the 2016 election. And what happened was that during a deportation hearing, this judge started talking about then presidential candidate Hillary Clinton, and the person facing deportation was also facing a 10-year bar in terms of trying to come back to the United States legally. And so she talked about how unfair the 10-year bar was, and how Hillary Clinton, if she's elected president, she'll get rid of the 10-year bar, and how but if she wants to do that, she's going to have to make sure there are Democratic members of Congress who are elected. She talked about the Republicans and all they're going to do is just deport everyone. So she really was talking up Hillary Clinton's campaign platform and not so much the Republican Party. And she did all of this from the bench while she was overseeing this deportation hearing. So obviously a very serious violation in terms of engaging in political activity in your official capacity. This is one that, again, that we took to the board. What happened was the employee, after we had the hearing, the employee ended up retiring. And so in the judge's order, he did what he could. He ordered a $1,000 fine and a 30-month debarment. But what I think is most significant is in his decision, he said that if she were still an employee, he would be ordering her suspended without pay for 120 days, which is obviously a very significant discipline.
Absolutely.
Another case worth mentioning, and something important to say about this is because we've had a couple cases with somewhat similar fact patterns, and they deal with candidates coming to visit agencies for campaign purposes. And, for those of you who work in agencies that candidates like to come visit, we know that you all have great policies and procedures in place for how to deal with those kind of requests that come in from campaigns or from candidates or maybe even congressional staff, and figuring out, what is official, what's political, and what can and can't happen in the federal workplace. And so my point here, as I bring up this case example, is that if you're in one of those agencies, just make sure employees know that there are policies and procedures to be followed, because in both of the cases, the employees basically went rogue and did what they wanted to do to bring these candidates into the workplace. And so one case that has some resolution involved an employee who worked at a very secure facility. Like, not just anyone could go into this facility. You had to have access, you had to have a badge, and you had to have an employee escorting you. This candidate had sought for several, at least 3 or 4 times, had attempted to get a tour of this secure facility that was in the district where she was running to be the representative of. And each time she was denied for agency policy reasons and for Hatch Act reasons. And this candidate happened to know someone who worked with our subject, and the subject agreed to give this candidate a tour and got her a badge, got her a hard hat that she needed, and granted her access to this secure facility, gave her a tour. The candidate's campaign took pictures while she was there, and they ended up on the campaign website. So this was a violation, obviously, of this prohibition. The employee actually ended up, after we filed a complaint against her, she resigned from her job and accepted a 3-year debarment from returning to federal service. The last case I want to mention, and then if you want to, we have a case that we are actually settling right now for a 30-day suspension. It involves a Postal Service employee. And in this case, the employee was a customer service employee who was working at the post office. And so a customer was in line to mail an absentee ballot. And this postal clerk said, okay, that'll be 71 cents. Unless you're a Democrat, then it'll be $5. And so, the employee, when we interviewed him, said he was, trying to be funny and joking around, but his attempt at humor had a real impact because someone else in the line overheard this conversation and was so fearful that her ballot wouldn't be properly handled by this Postal Service employee that she went elsewhere to mail it. And so, again, a very serious violation in the employee's official capacity, performing service to members of the public, and advocating against the Democratic Party.
And then two things that I want to add here. One is, I think all the examples, I don't know that we've done any examples involving supervisor and subordinate.
We have not, no.
But we're seeing more and more of these cases as well. So I think it's worth, even in terms of examples that you might use with your own staff. We currently are investigating a case of a supervisor that was handing out Trump bracelets to their staff. And in fact, we have evidence that the staff was then wearing the Trump bracelets while at work, and also inviting the staff to political fundraisers. We also have another allegation that we're investigating involving a case where the supervisor was regularly, as we understand it, making disparaging remarks about the president and Trump supporters. And this was happening at work and directed to the subordinates. So again, these violations are out there, and you would think that people would understand that this is not permissible, but it's happening. The last thing I want to say under use of official authority is that the conventions are coming. And we normally get a lot of questions around that time about especially agency principals traveling to the conventions and the Schedule Cs. And certainly individuals are, that's permissible activity to attend the conventions. The concern here, and especially why I'm addressing it under use of official authority, is that often we get a lot of questions about official trips or events that seem to get tacked on with the travel to the convention. And it's important that those that's then becomes a mixed trip, and it should be reviewed carefully. I am certain legitimate reasons why maybe an official trip is added to the convention travel, but those are things that should be reviewed carefully to avoid even appearance issues that sometimes arise when you have a mix of the convention and then official as well. So, but call us and we can help you with those issues. Okay. We can hit the last two restrictions, I think, pretty quickly. So the next prohibition, which is also a 24/7 prohibition, and so is the use of official authority, by the way, is the candidacy prohibition. All federal employees are prohibited from being candidates for partisan political office. This includes all partisan elections, regardless of whether they're at the federal, state, or local level. There's one exception that we'll discuss in a minute, but basically it's worth repeating because we've had a number of cases in the last couple of months where you have federal employees running for partisan office, and we've had to engage in discussions with the federal employees to try to bring them into compliance by either withdrawing from the race or resigning from their jobs. And some of these folks have been around for a while, so it's surprising that we continue to see candidacy violations. And in fact, one case that we're currently investigating is very serious because you had a supervisor who was running for local office in a partisan race and solicited a subordinate to support her. The employee, to make matters worse, was probationary. So there's that added element that the employee felt compelled to support the supervisor's endeavors in running in violation of the Hatch Act. And this supervisor also was asking that this probationary employee perform political chores for a congressional candidate. So a very serious case, and I'm sure as we complete our investigation, you'll be hearing more about that, but certainly a case that looks like it's ripe for disciplinary action. With candidacy, though, a couple of things. I mentioned earlier that there's an exception that has to do with employees that live in designated localities. If you're advising someone that lives in a designated locality, which means that they can run for local office even if the election is partisan, as long as the individual lives in the community in which the election is taking place, and they are running as an independent. If all those criteria are met, The individual can run for partisan office, but the rules concerning these designated localities are rules that we often don't work with and can be a little bit tricky. And we recently had to work with an employee who received incorrect advice about this issue to try to bring them into compliance. So we would ask that if you get questions about designated localities, that you work with our office to make sure the individuals are getting the best advice possible. Party office is not prohibited. It's not considered partisan office that's prohibited by the Hatch Act if you're less restricted. The last prohibition, which again is a 24/7 prohibition, is that federal employees may not encourage or discourage the political activity of anyone that has business before their employing office. This definitely would also be a prohibited use of official authority if we had a fact pattern that violated this prohibition. It would also be a use of official authority. Here, though, things to keep in mind: the business that is at issue is specifically defined by the statute, and this has to be a knowing violation. If you do not realize the individual had business before your employing office, then you've not violated the Hatch Act. Lastly, this slide is just a summary of all the social media rules that we've been discussing throughout. Further restricted employees, very quickly, the key thing here: everything that we've discussed applies to further restricted employees, in addition to the fact they may not actively participate, actively engage with a campaign or a political party. And all of the examples on the slide are examples of active participation with political campaigns or political management. And the last thing is penalties. I think everyone knows that there's a broad range of penalties, anywhere from a letter of reprimand up through removal. Were we going to add anything here? No. Okay. And then a list of cases. Sometimes we're asked for citation as you guys are reviewing a fact pattern. So Erica spoke about the most recent case with the ALJ. That's the DiPaolo decision. But here are some recent board decisions, as well as one important Second Circuit and Supreme Court decision on the Hatch Act. And lastly, here is our contact information. You've got our hotline. You've got the Hatch Act inbox. The hotline we try to respond to within 24 hours. The Hatch Act inbox, 3 to 5 business days. The one thing we've added here to this slide is our listserv. I know that there was some issue recently with people not being able to sign up for our listserv. I think we've worked out the issues.
Yes, the link is long, but it should work.
But it should work. So that's why we decided to add it to the slide so that everyone would have the link to the listserv. And we're trying to be more proactive in terms of content on our website and using the listserv to announce new things that we're doing.
Right, and especially when we do get our videos together, we'll be making sure that we announce them or maybe even distribute them via the listserv if we can.
Exactly. So I think that brings our presentation to a conclusion. Please feel free to reach out to us and call us if you have any questions, and we really appreciate your time. Thank you.